Okay, it is exactly 8:31 p.m. and today is Tuesday, September the 10th. Tuesday, September the 10th. And this is week 6. This is the final lecture. And I told you that the quarter would go pretty fast. And so we have finally reached the end. And so I'm going to spend some time today going over the material and going over the requirements for this week's assignment and make a few final comments to you as well. So let's go ahead and just get started now. Let me share my screen. You're familiar with this. Okay. And so down here, someone asked me about the live lecture. This is it right here. It's been the same thing all quarter. Rasmussen.webex.com/meet/Richard.Wright. That's if you're going to come in the original lecture. Of course, though, by the time you hear this, if you're not here, you're going to get one of the archives under the recording. And you can see that this is the final lecture. And so you'll see the lectures from week 1, 2, 3, 4, 5, and then under here you'll see week 6, and the link will be there. And I also will be emailing the link as well. So let's take a look at the announcement for this week. So this week, we're going to deal with defenses to criminal liability. And I sent to you the PowerPoints for Chapter 10 of the textbook, A Brief Introduction to Criminal Law. And I recommend that you look at the mental disorder and insanity defense. We'll talk a little bit about that tonight. Involuntary intoxication, mistake of fact, mistake of law, a little self-defense. And then finally, reminding you to go over these key terms for practice, dealing with mistake of law or fact, and then, of course, take the practice quiz. Because today you have your final quiz, which is the equivalent of a final exam, which encompasses weeks 4, 5, and 6 on the exam. And then there are practice quizzes in every one of those, so I would recommend you spend some time there to prepare. And then your discussion assignment, murder or self-defense. The initial post is due tonight at 11:59 p.m. Central Standard Time. Okay? And your reply posts are due this Saturday. Says, note the deadlines in the course calendar. Initial post and reply post by 11:59 p.m. Central Standard Time. But I'm telling you right now that your initial post is due tonight and your reply post is due Friday, the 13th, at 11:59 p.m. Central Standard Time. And then finally the quiz, which is your only written assignment other than a discussion post, and it is timed. And all due by Friday the 13th at 11:59 p.m. Central Standard Time. We're going to go over the calendar in just a minute. Also, I want to remind you, again, the term officially ends 11:59 p.m. Friday, September 13th. And then if you could, take time to complete the end of quarter student evaluations as well. All right. So now let's go into a final look at the course calendar. Take a look at that. And you'll see as soon as it pops up, which it is, you see where we are here. This is where we are. You see your reading assignment, and then you see your initial post, and then the lecture that's taking place here. And in addition to that, Friday the 13th, your reply post is due, your written assignment, which is the time quiz, and then your module for the key phrase. I think this is the first one here. No, that's the quiz. The second one I think is, oh, okay, now it's the when you do that, okay, now it should be second one. No, that's the quiz. This one should be, yeah, the live lecture, so that you give the keyword. All right, and that's it. The 13th. If you turn in stuff after the 13th, this cannot be graded. It will be a 0. Don't tell me I had technical problems or any of those kind of things. I'm sorry. The 13th is it. I cannot extend it. It is a school policy, and I will not break or violate school policies regardless. So let's take a look at Chapter 6. And let's, again, quickly, because it's not really that much to deal with in terms of assignments. The discussion posts. And then, so your initial post will be due tonight. And then your reply post will be due Friday night. Okay? Then your exam is set for 30 minutes. You'll have one opportunity. If you remember the midterm that you did in week 3, then it's the same number of questions. And again, I told you what you need to know, that you don't have to go back and study chapters 1, 2, and 3. You just have to study 3 chapters, chapters 4, 5, and 6, to be brought up to speed. And I highly recommend that you do so. And then your live classroom lecture. Okay? There is no rubric for writing or none of that. You're finished with that as of week 5. All right? So now let's go and look at the content, the lesson content itself. So we're going to talk about the insanity defense, involuntary intoxication, mistake of fact and law, and then we're going to conclude with dealing with self-defense. So you should be aware that affirmative defenses basically are defenses that say, yes, I did do the crime. Yes, I mean I did kill the person, or I did injure the person seriously, but I did it under what we call justifiable under the law. And so because of the state of mind dealing with the mental disorder, then the defenses are considered as excusing the action if it's determined that you fit under these. Now, I will tell you this, that in all my years of practicing and observing criminal cases, I hadn't seen very many successful affirmative defenses that relate to insanity. It is a very, very difficult thing to prove, and most jurisdictions, including Illinois, are pretty tough. And I'll talk a little bit about some examples of what I'm talking about. So what are we talking about in terms of the insanity defense? First of all, the thing is that what you're really arguing is that you did not have the mental capacity at the time of the crime to commit the crime. And you're not disputing, like I said again, that you committed the crime, but you're arguing that you didn't have the requisite or required knowledge or intent to commit the crime at that time. Or either some people use the term lay people, you were out of your mind at the time of the crime. And so affirmative defenses are in many jurisdictions based upon a person being found not guilty by reason of insanity. So what they're saying is that that individual will, if successful with the insanity defense, will be adjudicated or judged, found by the judge or the jury to be not guilty by reason of insanity. Now, let me say this, that when that happens, it doesn't mean that, okay, you're free to go. No, because your next stop generally is a mental hospital, and you will remain in that hospital until you are competent and safe to be released. Now, they won't try you again because that would be double jeopardy. So the judge, in terms of determining that the defendant is competent and safe to go back in the community at that time, and usually there are many reports that are provided based upon the treatment that that person may receive, and it takes a little while. It's not an overnight thing. There was a young man by the name of, I think his name was John Hinckley, that shot at the President of the United States, Ronald Reagan, and he ended up wounding a Secret Service agent who, at the current time, I think he may have retired, was the chief of police in a town near here called Orland Park. And then one of the, I think it was the press secretary, Brady, he was paralyzed based upon that. And so Hinckley remained in the hospital for many years. I think within the last couple of years, he was finally released from the hospital. Okay. Now, almost every state in the United States, with the exception of Idaho, Kansas, Montana, and Utah, have some kind of insanity defense. And in these 4 states that I mentioned, they do allow for guilty but mentally ill verdicts. They do allow for these. But in those states, if the defendant is determined to be not guilty because of mental disease or defect, the defendant may then be committed to a treatment hospital until deemed sane. It's the same thing. So the point of the matter is that that individual will still end up in the same type of situation as with the other 46 states as well. So there are 3 types of insanity defenses, and I'm going to go down each one, and you have to listen very carefully because they sound so very similar. And the first one I'm going to talk about is called the Norton Rule, and that's the M, the apostrophe, N-A-U-G-H-T-E-N rule, and it originated in England. And a person can be found not guilty by reason of insanity if, when they committed the offense, they had what they call the diseased mind, which prevented that person from recognizing the act they were doing was wrong. So it's a diseased mind defense, as other people might call it, or the right-wrong test. That individual could not discern right from wrong. Now, so at that time, what a defendant has to do is prove these 2 points mentioned here, that at the time of the homicide, that defendant thought that they were, for example, stabbing someone with a knife, but he thought the knife was a straw. In other words, didn't have the capacity to appreciate the fact that he was using a dangerous weapon and dagging at the person. Or, at the time of the murder, the defendant knew they were stabbing someone with a knife, but for some reason, the mental condition, they thought nothing was wrong with killing the victim at that particular time. So that's why it's called right/wrong test. In the state of Florida, Insanity defense, it says, states that all people are presumed to be sane, and that has to be brought forth by the defendant, and that's in every jurisdiction. And so at the time that the person, again, had a mental infirmity or disease or defect, and because of the condition, the defendant didn't know the consequences or appreciate the consequences, and didn't know that what they were doing and what the possible consequences could do, or that they did not know they were doing something wrong. So that's the right wrong. And so that's the Norton rule, okay? That is not the rule that many jurisdictions are using, but I'll tell you in a minute. Then there is the Durham rule, and you need to pay attention to these rules because they're going to come up on the test. I can tell you that already. The Durham rule, you don't have to worry about it, and you might not have it in the exams because it's only in one state, and that's New Hampshire, and it says it's known as the product of mental illness test. So you might want to just remember that the Durham test is the product of mental illness test. And according to that rule, that the acts of the person of mental disease or defect will excuse or defect excuse the criminal liability. And so the case came about in 1954, Durham versus U.S., which criticized the Norton rule, which is interesting because it's almost very close to it. For its capacity, for its simpler, it's saying it was too simple. That the mental illness and that some actions could be the product of mental illness. So the Durham test is more liberal than the Norton test and stretches the intellectual question of did the defendant know the difference between right and wrong that is expressed in Norton. So it gives the defendant more of an opportunity. That's why it's only in one jurisdiction. And then finally, we come to the third test, which is called the substantial capacity test, which is actually the standard that we utilize here in our jurisdiction, or at least was using, I know, at one time, because I've retired in 2000. But the substantial test came about because they were trying to unify the jurisdictions across the country and provide a model code so that Norton would be done away with between right and wrong, but rather as a result of the mental or defect lacked substantial capacity to either appreciate the wrongness or act or conform to requirements of law. An example of substantial capacity can be found in Wisconsin, which states that a person is responsible for criminal conduct, is not, responsible for criminal conduct if at the time that that conduct resulted from a mental disease or defect, and that the person lacks substantial capacity to appreciate the wrongfulness of their or conform to their conduct to the requirements of law. So again, back to the presumption that people are presumed to be sane, the burden shifts to the defendant to prove that they were insane. The burden of proof to be successful under insanity is not beyond a reasonable doubt, but a preponderance of the evidence or clear or convincing. So it's a lesser standard. So it makes it somewhat possible. But I can tell you this, that it is not easy, and there's a separate hearing that takes place that has to do with the determination of insanity, and the court determines if they were insane at the time. And there'll be psychologists, psychiatrists to examine the individual and provide expert opinion and testimony to the court. and the judge, in some cases the jury, in a decision as to whether or not the person is sane or competent if they're deemed insane. And then the person will then be ordered to get mental health until they're deemed healthy, mentally healthy. And then these individuals often spend the rest of their lives in secure hospitals or these very, very long periods of time. Now, one of the cases that I know of that resulted in a person being found not guilty by reason of insanity in Illinois was the Amanda Wallace case. Now, Amanda Wallace was a young lady who I had a chance to see her actually in the lockup when I went to visit another client, and she was in pretty bad shape. But let me tell you what happened with Amanda Wallace. Amanda Wallace was the DCFS, or the Department of Children and Family Services, which is a child protective agency in Illinois, took the child away from her. And some reason or another, and DCFS has been involved in several of these kinds of cases, but this is one of the most egregious ones, and the media just ate it up. They gave the baby back to Amanda Wallace, and a short period of time after she had the child, she, at first I thought she stabbed the child, but I would later find out that she hung the child. And that when she hung the child, she didn't appreciate at the time that she was hanging a child. I am looking for something while I'm talking to you. And so as a result of that, the lawyers were able to successfully prove that she was insane at the time that she committed the offense. And if you were to go to Google, you will see that it says that a 2-year-old was murdered by his mother in Chicago. The circumstances of the death of the child brought out public outcry, and so what happened is that there were articles that were written all about it, and so it was felt that they should have been able to recognize that she was mentally ill, and so she killed the child, with an electrical cord. That's what she did. I think she choked the child, and so the bottom line is that DCFS fumbled the ball there, and she was sentenced from that particular point. Well, anyway, when I saw Amanda Wallace was sitting in a corner, and she was rocking back and forth, side to side, and you could tell that there were some things wrong. And it is very difficult to fake that, and so that's one of the most clearest cases that I know of. But be aware, as I said, they're far and few in between. So now let's talk about involuntary intoxication. So involuntary intoxication means what it says. It says that a person can't do it voluntarily. Get a drink, get high, and then claim intoxication as a defense. No, you did it yourself. But generally, these defenses apply in cases where there was no intent or state of the mind, or that the person didn't know the difference between right and wrong, and that the fact was they were involuntarily intoxicated. And so how did you become involuntarily intoxicated? If a person had a Mickey slipped in their drink, or if, for example, taken the prescription medicine, taken 2 doses and didn't realize it, for example, then they could be used that involuntary intoxication. But here's a couple of statutes. In state of Michigan, under the influence or impaired by alcohol or drug as a defense, it's an affirmative defense to a crime, specific intent crime, for which the sentencing defendant would have the burden of preponderance of the evidence. Same standard. You'll hear that in all the affirmative defense cases, that they voluntarily consumed, legally obtained, and properly used medication, and didn't know, or really should not have known, that they would get intoxicated. In Kansas, it says that a person charged with a crime of intoxication committed only if under such conditions was involuntarily produced and rendered such person substantially in knowing or understanding the wrongfulness of that. Again, remember, it has to be involuntary. Now let's by looking at this example here of involuntary intoxication argument. So if a person has their drink spiked, and for example, let's look at what happened here in this scenario. This college student by the name of Jim, he partied, had a test the next day, and he didn't want to fall asleep. So one of his classmates offers him, tells him it's caffeine and that'll keep him alert. However, the classmate didn't tell the truth, and the pill was actually a prescription methamphetamine hydrochloride pill, and Jim had an adverse effect to it, causing him to go into panic and rage. So while in this state, he breaks the window of the store, destroys merchandise before the police arrest him. So if Jim can prove that he was involuntarily intoxicated, he may be found not guilty of vandalism, of the crime itself, because it was not something that he did on purpose or unknowingly. Again, so that's pretty much, it has to be unknowing, unintentional, and accidental in a situation, or the reasonable person would know but didn't have the capacity to know. Now, it could be argued that Jim should have considered more before he took it, but I think in the normal course of the environment that he was in, that's a common thing. When I was in law school, I remember they had this cola called Jolt, and Jolt had more caffeine than Mountain Dew. As you should know, Mountain Dew contains a high content of caffeine, especially that code red. And so people would drink those to stay awake, to study long hours. And so that's what this person thought that this white pill would do. So that's involuntary intoxication. Now let's talk about mistake of fact and mistake of law. First, mistake of fact. In a mistake of fact is that when a person, they didn't understand the facts that took place. Now, remember, ignorance of the law is not an excuse. That is not what we're talking about. But take a look at this statute from Missouri, which gives an idea of really what mistake of fact is. A person is not relieved of criminal liability conduct because they engage in the conduct under a mistaken belief or fact of law, unless that mistake would negate their mental state as required. So under the Missouri law, like the mistake of fact statutes, the defense can be claimed if the mistaken action is related to an element of law in question. So let's look at the example here, which brings it home. Lisa made a large purchase of at a home goods store. She was pushing the mower in a large box, which she put at the bottom of the cart. The bottom of her cart was filled with other items, and while paying for items, she was distracted by her cell phone and didn't pay attention to the clerk to ensure that the items were scanned. And Lisa pays with a large bill of her debt and exits the store. So after she leaves the store, a loss prevention officer, or store detective that some people call them, tells her she didn't pay for the lawnmower. Well, the loss prevention officer calls the police and requests that she be charged with theft. Now, Lisa would probably be successful, and the police would probably say, she'd say, "Well, I didn't realize it. I'm sorry. I'll pay," and she'd likely claim mistake of fact because she had every intent to pay for the merchandise. But the clerk neglected. This happens quite frequently in situations. If you've been to Walmart before and you see people that have water at the bottom of their cart, I've had that happen many a times. But I have a habit of always saying, and many people, that, hey, I have water down there, make sure you scan the water. But if, for example, inadvertently something happens, well, Walmart has a situation where if they see it down there, they'll ask to see your receipt, and then they will tell you, oh, this wasn't paid for, and then you go back and pay for it. So, I mean, the key thing is that the mind that that person had at the time that the act happened was very simply a mistake and was not intent to commit a crime. And that's basically mistake of fact. Mistake of law is a defense that's a little different. It's claimed when a person violates the law, but they believe their actions were indeed. Now, it's not the same as ignorance of the law, because you're supposed to know the law and know wrong and know that exists. And so here's some examples where mistake can be applied. A person relied on a law that was later found unconstitutional. So at the time, they weren't lawyers, or even if they were lawyers, it still doesn't matter. If it's determined unconstitutional, then they didn't violate the law. And so there are people who have been found guilty under laws that were later deemed unconstitutional, and then they were given new trials. A person acts in good faith with a decision, but didn't apply it correctly. That can happen even to lawyers. A person acted upon advice that was given by a person responsible for administering the law. Let's say a police officer told them something that they could do, then it's determined that they actually violated the law. Their argument could be a mistake of law based on the advice of that police officer, because they should be able to rely upon that police officer or law enforcement officer to have given them proper advice. And then finally, it says a person commits an act contrary to law that's not yet published. In other words, it's not known to the public, and so it's not really, so you can argue mistake of law. And so then you look at a mistake of law in North Dakota. And this is kind of similar to what we just got through talking about. And which states that a person's good faith belief that conduct doesn't constitute a crime can be an affirmative defense. Remember, I said that already. Reasonable reliance upon a statement of law contained in a statute, a judicial, administrative order, permission, or basically the same things that we talked about earlier. All right. So the key thing is that ignorance of the law is not what we're talking about, but the defense if mistakes are made based upon some of these types of scenarios that we had gone in here. And Paul's example here makes it clear that he had a suspended license and he wanted to drive his ATV to work. So the local officer told her, it's okay, even though your license is meant to operate an ATV. One day, Paul was stopped for speeding on his ATV and cited for operating with a suspended license. He was convicted, um, and the trial court didn't permit the jury to consider mistake when rendering his decision. So on appeal, Paul got the conviction overturned because he should have mistake of law defense. Okay, so he only drove his ATV because of bad advice that was given by a chief deputy charged with enforcing the law. That was kind of like what we talked about a few minutes ago about an official given the advice, like a person active on the advice given by a person responsible for administering the law. Okay. And so we come to, I think this is it. Yeah, we come to the end, and we talk about self-defense. Self-defense means what it says: defending yourself or protecting someone else from being injured. Now, self-defense laws don't presume that you can use force, but the burden of proof, again, because it's an affirmative defense, prove that it was lawful what that person did. Now, here's the thing. An individual must meet with the same defense. Same action. I had my very first case that I did. That was a serious case, a double murder case, where a young man was found not guilty because of self-defense. And here's kind of like the facts that happened here. This young man was hosting a crap game, and he let these two guys in, and as he was locking the door, he turned around, and there was about 5 or 6 steps that he had to go up to get on the level that they were. When those guys got to the top, they announced a robbery. Well, my guy got his gun out, and he was able to tell them to drop the gun, and they didn't, and they turned toward him, and then he fired shots, and they hit the ground. Well, then he came up the stairs and shot them in the back several times. So everybody around said, man, this is going to be tough. You're going to be trying to prove self-defense in a situation where he fired more shots in the back than in the front. And that does make it pretty difficult. However, one of the key things that went my way was the coroner's report, which pretty much made it quite clear that the shots that were fatal to those guys were fired consistent with him shooting upward from a lower level, and that they were facing because the bullets pierced the aorta or vein near the heart, and that it went upward, and so when they hit the ground, he fired shots in their backs. Well, the question I asked the medical examiner, I says, so what about the shots that he fired in their back? They says they were already dead. So what would you say the cause of death was? A shot, single shot, consistent with a person facing the person. And it was very clear from all the witnesses that there were guns that were brandished. And so he was found not guilty of it because he used a gun. And so the key thing to remember is that he acted in self-defense because he was protecting himself and others. Now, let's look at the scenario of Bob. Bob is walking on the sidewalk with his girlfriend and approached by a drunk man who threatens to punch Bob. And Bob tries to get away and avoid the conflict and tells the man, just keep walking. And the man then shoves Bob and draws his fist back to hit him. Well, Bob punches the man in the face, and he falls onto the ground. Upset because the man just tried to assault him, he jumps on the man and beats him until he becomes unconscious. And Margaret pulls Bob off the guy, and they wait for police to arrive. So the question asked, and it's pretty easy actually here, was the force initially by used Bob to stop the intoxicated man from hitting him legal and justified? And the answer is yes. But then when he got on top of the man and beat him until he was unconscious, he went too far. And then he could be found guilty of involuntary manslaughter. And so the Illinois statute talks about this, and for justifiable use of force. To deal with those questions, notice what it says, and I'm very familiar with this one. A person is justified in the use of force against another when, and to the extent they reasonably believe that the conduct is necessary to defend themselves or another. That's what I said earlier. An imminent use of unlawful force, from an imminent use of unlawful force. However, he is justified in using deadly force only if is a belief that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the commission of a forceful felony. That's what happened in the case that I just told you about, where I represented that young man. So it makes it quite clear that Bob's initial force was justified, but the subsequent actions of jumping up on the man until he was unconscious, he went beyond that, and self-defense would be negated from that particular point. Okay. Now, many states in the U.S. don't require a person to retreat before they use self-defense. That referred to as stand your ground, which everybody knows almost all over because of the Trayvon Martin case. It doesn't require a person retreat, but it presumes that they were not engaged in unlawful activity or have the right to be present where the act occurred. So that means that basically we're in a right place where something occurred. Before using the force to stop the unlawful interference then. So a person can't assert a stand your ground claim if they committing a crime while they are, individuals cannot stand your ground claim if they are committing a crime when they are attacked. And so it must be justifiable where they are and what they're doing. And also, people can't claim self-defenses in cases where provoke the attack. And so, anyway, be aware of the stand your ground and the duty to retreat. Many jurisdictions don't apply the duty to retreat. I never did like the duty to retreat because it places a burden on a person to hurt themselves or others, or it's a time of the essence thing, and that's it. Okay, so that's self-defense. The battered women syndrome is basically a defense that is argued when a person has been the victim of constant battering probably in most domestic violence scenarios, where it's called BWS, or battered women syndrome, and been used in cases to justify murder of the abuse of their abuser, and it deals with the mental state that comes about at the time that the person commits the offense. Now, let me say this. I have a young lady that I know who was the victim of being abused and beaten constantly by her husband. And one day what she did was she waited for him to go to sleep. And then she got a gun and shot him and killed him. And she was found guilty of murder in the second degree. But the transcript was that the lawyer didn't focus too much on explaining the state of mind of that individual at the time they committed the offense based upon the history of this guy, and would have been probably successful with that jury trial if he was able to make it pretty clear to those individuals that if he woke up as he had awakened from the past, he would beat her, and she wouldn't have the ability or time to do that. So though it still doesn't quite meet the standard, it's still a possibility. Let's take a look at this scenario here. It says BWS, battered women syndrome, claimed in instances where domestic abusers believe they are in constant state of imminent danger. And that's what happens. The mind conjures it up based upon the way that they have been treated, and that they can't escape the environment or the relationship. The person would follow them or track them down, so they resort to violence. So let's use this example here. Diane, physically abused and battered multiple times by her husband, Jim, over the past 10 years of their marriage. Each time Jim is drunk, and that's when she's battered, and the worst has ever been, and knocked out and choked before. So one night Jim comes home drunk, and they begin to argue over Jim's drinking problem. Jim begins to escalate, and Diane, his wife, fearful that she would be substantially battered again, shoots Jim. She's likely to argue self-defense in conjunction with BWS. And she could probably be successful in that scenario, which is different from the one that I shared with you a few minutes ago. So in an actual case of BWS, battered women syndrome, you can take a look at, there's a video in here, Abused, on your own time that you can take a look at. But it is a defense, and it's been pretty successful there. So finally, let's look at two other things. The castle doctrine. The castle doctrine is originated from the thing that you've heard, that your home is your castle. And basically what it is saying, just to kind of like capture the essence of it, is that a person have a right to protect their home or individuals in their home from individuals and or their dwelling and or their vehicles when the person believes that the act is unlawful and was occurring or had not occurred. Now, it doesn't matter whether the person had a weapon or not, because of the fact that you violated their home. And so the castle doctrine permits a defense to use deadly weapon or deadly force to stop an intrusion in your home. Okay? It doesn't require the person to prove that they could have gotten out or retreated, but simply that the person unlawfully entered the dwelling, and it's presumed that with the intent to create bodily harm or death to them or someone in the dwelling. Okay? So people within the dwelling, when the unlawful entry is made, can use deadly force to stop the intrusion. Don't have to wait to determine if that, because they don't have to wait for threats by that individual. All right? And the fact that it's a protected area allows it, and that's pretty much what that is. And so I'm going to go and conclude by talking about police officers using force. Police officers are held to a high standard because of the fact that they are legally carrying weapons and operating under the law. And so sometimes the force that they use may be going too far, such as it says sometimes the force used, like hitting a person with a baton to take them into custody, could cause bodily harm or even substantial harm. So once force is reasonable to make the arrest, the officer will not be charged with battery. But in contrast, similar force applied by a citizen might subject that person to arrest for battery. However, though, anytime a police officer uses force, there is a review of that to determine whether or not that force is excessive based upon all the attendant circumstances of reasonable law enforcement officer. And so the public media scrutinizes it very carefully, as well as what they call oftentimes a civilian review board looks at it. But oftentimes police officers' use of deadly force is rare, and police officers show great restraint when making deadly force. And that depends. That's arguable based upon your community and probably who you are. I would tend to say that African Americans tend to, and other minorities would tend to disagree with that statement. And then there is Second Amendment perspective. Sometimes the mere presence of a firearm can prevent the use of deadly force. So people use that now because you got a lot of carry concealed, carry open people who are using their weapons as well. And so that's when you get into this Second Amendment issue. So that's pretty much it. I want you to be aware to study for what we just covered here. For example, if you click on key terms, it's going to pop up in a minute. And you go to these flashcards, then do that, and then allow it. You'll be able to see it in a second. Here it comes. So you go through these little flashcards. A defense that can be claimed if the person violated the law, but indeed that his or her actions were indeed legal. Mistake of law. A defense raised in domestic violence cases where victims demonstrate a pattern of abuse that justified their actions, such as killing their abuser to prevent further harm. Battered women syndrome. And you can go on to the last one. Applied to the intoxication defense, the level of proof necessary to successfully prove intoxication. A preponderance of the evidence reflects as expressed as 51% certainty. Merely more than half certain is preponderance of the evidence. And so you look at these, and you see what I'm talking about. Okay, let's go to the next section. Scrolling back down to the bottom. And you see mistake of law, and you can go through these same kind of scenarios, and you can start the activity, and then you go through and you read these, and then select whether it's mistake of law or mistake of fact. Okay, so Jane has a white cat named Snowball that wears a pink collar and is let outside each day. One day the cat doesn't return. A few days later, while out looking for the cat, she finds Snowball and brings her home. However, later that same day, she realizes that the pink collar has a tag with the name Princess on it. Okay, Jane contacts the police, but fears that she will be arrested for theft. So what is her defense? Mistake of fact. So you put that in there, and that's correct. Okay, and then you go to the next one, the last one I'm going to do. Eric waves down a police officer and asks, my landlord locked me out of my apartment. Can I break in and get my stuff? Police officer responds, go ahead, it's your place. Eric breaks in, and the landlord demands that he's arrested for burglary. He's going to say mistake of law, because look who told him he can do it. Let's go back. Let's go back to okay, I don't think you can do that. Okay, so anyway, a mistake of law. Okay. And then the last thing here is please take time to do this practice quiz. I've said it before, and it looks kind of like some of the things here. And it gives a scenario here. And you pick up the blank rule or test would be the most appropriate. Listen to what it says. You are defending a case where the defendant is accused of killing his girlfriend during a schizophrenic episode and believed he had to kill his friend because he was the devil. You don't believe that Derek knew the difference between right and wrong. What test would be most applicable? What's the right-wrong test? Norton. And that's how you do that. Okay? And then you continue on to the next one. I'm not going to do any more of those because we're running out of time. So anyway, take the time to prepare by going back and looking at modules 4, 5, and 6 and doing these exercises. And also looking at the material, but make sure you do these little exercises I did at the end that will help you to prepare for the final exam. And so with that, I'm going to say good night, and I'm going to give you a key phrase. And the phrase that I want you to use is criminal defense. Criminal defense. That's what I want you to use, just criminal defense. Okay? So with that, I'm going to say good night to you. I'm going to say to you, I hope that you learned a lot this past 6 weeks that will help you. And I wish you the best in your careers in criminal justice. Hope to see many of you in future classes. You know how to reach me. All assignments, don't worry about what you have or have not completed. I'm working on week 4, and all grades will be final and in by Monday evening, Monday night. So if you go and check on Tuesday, you will see your final grades. And so all your assignments that are in from week 4 and 5, you know, those are your written assignments pretty much. Then, because you already got the discussion posts that I put in for all of the weeks except week 6, which we're just starting now. So with that, I'm going to say good night to you.